Larzo?
Yes, ma'am.
And Mr. Larzo, in cause number 26 DCCR 0770, you're charged with the third-degree felony offense of obstruction or retaliation from March 8th of 2026. Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a second-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
You can repeat that for me?
What part of it do you not understand?
The first part.
What you're charged with?
The part where you said.
So here's the thing. You're charged with obstruction or retaliation.
Correct.
The offense date is March 8th of 2026.
Correct.
And that's a third-degree felony.
Correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a second-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. Do you understand? Sure.
Well, what it says is if you convicted, if you catch the case, 2 of the cases at the same time, then that would be consist of the enhancements. If you put both of those charges at the same time, I didn't catch those charges at the same time, even though I was convicted at the same time because they ran a CC.
Here's the thing. It only matters on one of them, right? Because the fact that they were run CC is what makes this enhanced by 1 instead of turning it into a habitual. So I'm only counting it like it's 1, right? So let's just assume you have 1 prior conviction. It doesn't matter if you have 1 or 2 or 14 from the same day, the same conviction day. It only will enhance this 1 level, which means from a third degree to a second degree, just like I said. Make sense? Okay. So
I'm sorry to interrupt,
Sure.
if I may.
Yes.
For the benefit of the defendant, I've tendered that pen pack to Mr. Rojas. The convictions are on the same day, but for the actual same type of offense. And in this instance, he threatened to murder a police officer, which is why the offer is what it is. And for his benefit, I also tend to introduce a punishment where available by the rules of evidence, the misdemeanor and juvenile contacts with the law that he has had as well.
all right. Thank you, Ms. Malfino. So you've had an opportunity to visit with Mr. Rojas about your case. And Mr. Rojas, do y'all have an announcement?
Judge, I was speaking with Mr. Larzo yesterday. I think his intention is to come here this morning and ask for a new lawyer. I explained to him the way to get a new lawyer is to reject the offer and set it for trial, because I think that was originally his intention. He, however, didn't want to sign any paperwork with me.
Because I haven't got an offer. You haven't gave me an offer. You said 5-year cap. I don't know what that is. That's not an offer. If you offer me 5 years TDC or you offer me 5 years probation, you didn't say which one. So when I get an offer, I'll let you know. I don't know what the offer is.
Sounds like the offer was a 5-year cap. Is that correct,
That's the
Mr.
offer.
Rojas? And I'm sure Mr. Rojas explained to you what a cap is.
Yeah, he just said I can't get more than 5 years.
Right.
Okay, so what is the offer? How many years? 5 years TDC?
So it's up to me. So if you sign for a cap, and I'm sure Mr. Rojas explained this to you, it's a way for you to try to come to me and say, give me less than 5. I could give you 5, 4, 3, 2, or I could consider probation. It would all depend on the information that I received at a sentencing hearing. But if I follow the agreement, I couldn't give you more than 5. So it's something where it's not for sure. You have an opportunity to ask for something within that range. Does
I'm
that
trying to tell me this today.
what?
I would like to take care of this today.
Well, talk to your attorney and listen to what he has to say. And if y'all want to take care of it today, then there's some paperwork that you have to go over with and sign, and then we'll go forward. All right. You can go back with the baby. Birds are allowed. Yeah. All right, Mr. Larzo, what's going on?
Ma'am, I'm going ahead. I want to request a new lawyer. He's not representative.
Here's the thing. You don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not just because
Can I speak?
Nope, not while I'm talking. I already gave you an opportunity earlier, and I'm going to give you an opportunity in a minute, but I want you to listen carefully to what I have to say first. Okay. Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on. I understand, but
You
listen,
want to let me speak, man? Please, can I speak? Please?
I'm going to let you speak, but I'm going to give you what your options are. Okay.
I just want. All I want is a. What I'm saying, you trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He already said.
sure
I said you haven't. He have not one asked me what happened. He hasn't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking
I'm not in
questions.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's what he's telling you. The evidence is what's in.
That's what the police report said, but he hasn't asked me my side. And
Here's the thing, your side is important if you're going to, if you didn't do it, what his job is to tell you this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready to go to trial.
Is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have some media?
Judge, I have requested the media. What I told Mr. Larzo yesterday when he told me he wanted to watch the video, I told him we could reset the date to look at the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want to because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would bring the videos. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful. Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
May I ask a question,
Go,
please?
nope, I'm done today. Go back with the
I'm not
bailiff.
understanding how you can give somebody 4 years for an aggravated charge
Let's go.
and try to offer me 5 years for non-aggravated.
So he's not happy with that.
DeMarcus Elam, wait, hold on. Mr. Burbank, what are you doing on, Mouton?
I missed the time,
I know. What's the announcements?
I'm still on discovery. I just got appointed and I've talked to her. I think also based on that, I may need to have her evaluated somewhere between here and there. My request, based on the circumstances.
What?
Evaluate.
Somewhere between here and there?
Yeah, well, my motion is here between here and there. It's the evaluation. It's coming,
Okay.
like today or tomorrow.
Okay, we'll reset this Mouton.
And I've talked to her. She knows what's going on and
All right, yeah, if you'll make sure you get that in, we will get her evaluated as quickly as possible.
maybe I can convince Mr. Smith to.
DeMarcus Elam,
Just
yeah, DeMarcus Elam. Mr. Smith, you've got DeMarcus Elam, writ hearing. Good morning. Are you DeMarcus Elam?
Yes, ma'am.
And this is cause number 26, DCCR 1221. Mr. Elam is charged with the first degree felony offense of murder. And Mr. Reynolds was appointed as attorney. Ms. Holmes is stepping in to help out on that as well. And they have filed a writ requesting for a reduction in Mr. Elam's bond, which is currently set. Oh,
Yes.
oh,
Yes, I believe Mr.
did I
Elam.
know that ahead of time?
I'm sorry if I didn't make that clear.
No, I guess not, because I'm not gonna, so here's the thing, when you have an attorney, you don't get to have what we call dual representation. So if you, and I don't mind,
I think if I could clarify, it was filed pre-indictment. I'm not sure when Mr. Reynolds was placed on it, but Mr. Elam had filed the writ prior to being indicted, and then after the writ was filed, his case
was indicted.
was indicted.
So it's been indicted at this point.
Yes, ma'am.
Okay. So here's what I'm going to do. What's the bond currently set at?
2 million.
Okay. So what I'd like to do, I'm not going to, because the case has been indicted. At this point, a writ is probably not the appropriate tool. I would think it would just be a motion for a bond reduction. Ms. Holmes can talk with Mr. Reynolds. They can get that filed. They're going to file things on your behalf. Okay. And so I understand that you were waiting on an indictment but that's been taken care of now, but you don't get to file something if you have an attorney. I'm going to take what they filed. So let's get a bond reduction. Ms. Holmes will get that filed for you. I'll reset the case 1 week, but I think we need to have the appropriate tool moving forward legally. Let's do 2 weeks, and we'll have a bond hearing. If the state has any evidence, that'll give them some time to bring anybody, if you wish, on a bond reduction hearing. Okay, so we'll see you back in 2 weeks.
Okay.
Good morning. Are you Joey Mink?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
He will, Your Honor.
I'm gonna need,
And Judge, I'm going to give you a heads up on this. The motions were, you're going to shake your head if they don't match up, or if they've been administratively difficult, for lack of a better.
let me get them printed out real quick, and we can all be.
At one point in time, the probation department only wanted one filed, and then the clerk asked why there wasn't two filed, brought that to my attention. So I filed the second one. So if there's errors, I apologize in advance.
So we'll just start with the first one. There's Mr. Mink in cause number, and he'll waive the formal reading in both.
He will.
Okay. So Mr. Mink, in cause number 23 DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct? And in cause number 24 DCCR 0294, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for aggravated assault with a deadly weapon, a second degree felony, and that was a 6-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you violated the special amendment requiring you to successfully re-enter the safety program. And is that true or not true? True or not true? And then in cause number 24 DCCR 0294, that motion also alleges in count 2 that you failed to provide verification of performing the community services required. Is that true or not true?
True.
And count 3 in that case alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to all of those counts freely and voluntarily? And did you plead true to them because they're actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
This one.
Do you fully understand them?
This one.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? State tenders number 1 in each case?
No objection, Your Honor.
It's admitted in each case. And is the punishment the same?
Yeah.
Okay. All right. I'm going to find in each of your cases that you entered your pleas of pleas of true to counts 1 in the one case and then 1, 2, and 3 in the other, freely and voluntarily. Find all of those counts true. In cause number 23, DCCR 1851, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 0294, find counts 1, 2, and 3 true. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. The 2 cases or the 2 sentences will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff.
Okay.